afternoon. Thank you very much for inviting me. It's a great pleasure to be here. And thank you for that lovely introduction. As I was introduced, I was a lawyer, and now I teach medical law and ethics at King's College London in the medical school, which I think is one of the biggest in Europe. And I'm a member of 3 clinical ethics committees in London, and I really enjoy being a member and part of those discussions. What I'm going to do today for an hour is just get us to think about the relevance of best interests in healthcare decision making and how we might go about thinking about it and applying that in practical situations. So I'm not just going to stand here and talk to you. I hope you're going to give me some of your views as we go along. Now I've got two bits of things to do here. Where's this? Okay. This is basically what I want to cover, and I hope this isn't going to seem too off-putting, because I want to bring in some cases for us to think about. But if we just put in context the relevance of best interests, and I think it really underpins healthcare decision-making and creates real problems where there's a disagreement about best interests. So I'm very interested in thinking, well, what do we mean by best interests? What are the different elements of best interests? And which particular views predominate where there is a conflict? And also, perhaps importantly for you, how you evidence best interests. What sort of things are you going to take into account? So I think it's important that we kind of identify what we mean by best interests. You know, there is no definition in the Act. I'll talk about that. And also the different elements of it. So to some extent it looks like an objective test, what's in the patient's best interest, but the test also asks us to think about the patient's values and beliefs. And so there's a subjective element there, and how much weight to give to those different parts. Also, there might be a difference between what the patient is saying now when they lack competence and what they said beforehand. And which are we going to give greater weight to? I'm going to look at a very interesting case that came out of England and Wales High Court last year, WNM, which involved a woman in minimally conscious state. And I'll ask you to think about facts, and you might decide what you think was in the patient's best interest, and then I'll tell you what the court decided. And then right at the end, we'll think about the case of Mr. Chan, which those who are attending the workshops, we can think about in more detail. So I hope that contents list is not too off-putting. So the relevance of best interest. Well, in your Mental Capacity Act of 2008, you've got a definition or a sort of a conglomerate of the factors that make up best interests. And that is very similar to our Mental Capacity Act 2005 in England and Wales. Very similar terminology. And so I'm going to be thinking about your act, but also trying to import some issues from England about how we have, interpreted the law. And here we are, when best interests comes into effect. So when we have a patient lacking capacity who has not made an advanced directive, an advanced decision. And these are 2 cases which I think illustrate the different ways to think about it. So here we have a woman with severe learning disability. So her competence has always been compromised. Clearly she could make some decisions, but not presumably of grave medical decisions. And she has uterine cancer, but she says, I don't want treatment. This is a non-competence decision, but she's still giving through her behaviours and articulating her wishes. She's frightened of hospitals and needles. And I think the question here is, well, how much weight do we give to those views when they're counterintuitive to her medical best interests? In other words, she might need treatment for cancer. It seems that that's the case here. And here the man who has dementia. So he has been competent in the past, and part of his values have been centred around his religious views. He's a Christian Scientist. He wouldn't have the agreed to medical treatment. So when he was competent, he would have refused it. Now he lacks capacity, and his adult children said, well, he wouldn't want treatment. So now what do we do? What's in his best interests? Is it to treat him, or is it to give effect to his wishes? And we don't necessarily know his wishes, they're articulated by his family. So our two acts give some indication of the importance of best interests, but have no real definition of what is meant by best interests. So we don't have a clear definition in the act. And there are many ways we could think about best interests. So we might think about somebody's well-being. We might think about satisfying their preferences. And we might think about a life worth living, so the quality of that person's life. And we can already see that taking into account these different elements might create a conflict. So in the previous cases, preference satisfaction, if the patient, an incompetent patient is saying, no, I don't want treatment, but that treatment would enhance their well-being, then we have a potential conflict. I think it's very important for us to remember that best interest is not just about clinical best interests. I mean, that might be easier to take on board. If I do this, then this is the likely outcome. If I do this treatment, this is the likely outcome and the likely risks. But best interest is wider than that, and that's something I would like to explore. It's not just about clinical best interest, but it's about wider holistic interests. And those might be quite difficult to pin down and to evidence. And there have been some criticisms of best interests as a concept. So best interest is a standard for decision making for people who lack capacity. And Coleman here says that really best interest is too vague. It's unknowable, it's dangerous, and it's open to abuse. And I think we have to be clear that in considering best interests, we really think carefully about how we can give some sort of evidence or process for decision making whereby our views about best interests are well thought through, and that really is the object of this lecture and workshops. Now, I'm not going to spend too long on this because I'm sure you know it and we don't want to get too tied up in detail, but if I can just highlight some what I think are quite important elements of the Mental Capacity Act. So this is your Singapore Act, and as I said, almost identical terminology in the England and Wales Act. So the person making the determination about best interest must consider all relevant circumstances. That's quite an onerous undertaking, isn't it? And must consider as far as is reasonably ascertainable. So that might not mean an emergency, but otherwise, how would you reasonably ascertain the person's past and present wishes and feelings, and any beliefs and values that would be likely to influence decision, and any other factors. Now that's pretty wide. And how are you going to do that? Well, if practical and appropriate, consult others about this. So someone named to be consulted, anyone engaged in caring for the person or interested in their welfare. So that's going to be family members probably and carers. And so really it's important, I suppose, if we're going to think about best interests and the wider holistic values, to take account of others' views. Now, you may want to add some other points here, but this is kind of a schematic view, I think, of some elements that we might think about with best interests. And as I said, we'll look at these when we get to some cases. So we might be thinking about, sanctity and quality of life arguments. If we come from a culture where sanctity of life is given an enormous amount of weight, then we're going to really put a lot of emphasis on preservation of life. And compare that with, the very poor quality of life. How poor does the quality of life have to be such that it might outweigh considerations of preservation of life? We might be thinking, and I think this is it, wrong button. We might be thinking particularly importantly about the benefits and burdens of treatment. and how we identify the benefits and burdens. Also, perhaps, the awareness and suffering of the patient. So if the patient is going to be suffering through treatment, that will be a burden to be considered. If the patient is insensate, then we might take a different view about the nature of the interventions that could take place. And I think this is the tricky bit. This is what Section 6 asks you to consider: the patient's wishes, feelings, values and beliefs. That goes into best interests as well. And perhaps also the goal of treatment. Is treatment futile? What's it seeking to achieve? And what's the likely outcomes? Do you think there's any issues I've missed out there? Would anybody like to import any other ideas into best interests? Well, we can see some later, perhaps. But as we can see, it's kind of multidimensional, isn't it? I think what is important is to think about the process for determining best interests. Because it's not just enough for somebody to say, yeah, this treatment is in the patient's best interests. It's got to be a well thought through decision. And best interest isn't just what a healthcare professional says it is, or indeed a family member says it is. So the decision maker, whoever that might be, can't just impose their views. They must have objective reasons for their decisions, and also be able to evidence that. And that might be, making very clear notes about why the decision was taken, and particularly thinking through the balance of harms and benefits. So I know that in England and Wales, and my medical students get rather confused about, well, who is the decision maker? Who is responsible for making the decision? And the person who is responsible for making the decision is one who has the clinical care of that patient, has responsibility for making those decisions. It might be a lasting power of attorney. It might be somebody in a care home. In a hospital setting, it would be, the clinical view. So at least, the family do not have authority to make decisions. They're part of the decision-making process. And we've got what we would consider, I think this is a helpful way of thinking about it, and I'm going to ask you to think about this balance sheet approach. But a balance sheet approach to best interests, and if we look at some cases in England and Wales, this is exactly what the courts do. In the judgment, we can see all the benefits for treatment listed, and we can see all the harms of treatment listed. And so the English courts take quite a schematic approach to this. What are harms and benefits? Now, what to put in the balance sheet? Well, you're going to have some factors of actual benefit, things that can be measured or anticipated. Although, as we know, nothing is necessarily clearly predictable. But it might be that by carrying out this treatment, we can preserve the patient's life, or relieve symptoms, or improve the patient's condition. And factors of actual benefit will go into the balance sheet. Equally, disadvantages might go in, and that might be the risk of treatment, and long or short-term harms, discomfort from the operation. But in this balance sheet will also go other more holistic concerns, and that might include, particular cultural interests, religious views, etc. And they're less easy to measure. I think it's quite important for us to try and think about what is best interests trying to achieve. And I think this is the difficulty between the subjective and the objective element. In the US, for example, if a person can't make a decision because of lack of competence, then they use the substituted judgment model. And that is asking, what would the patient want? Best interest doesn't have that. It has an element of that, but it is not a substituted judgment test. Substituted judgment is requiring us to put ourselves into the position of the patient and say, what would the patient have wanted? But the best interest standard that we use is asking a more objective test. It's saying, looking at this balance of benefits and harms, what is objectively in the patient's best interest? Now that might be a bit difficult because of course we all come to decisions with certain values, don't we? So ostensibly, best interest is an objective test, but it also involves an element of subjectivity. It's also saying, well, what would the patient, it involves an element of subjective substituted judgment because it's asking about the patient's wishes and feelings and values and beliefs. And I think it's this mix of objective and subjective element that's problematic. So my question really to you is, well, if the Mental Capacity Act asks us to consider the patient's wishes, feelings, values and beliefs, then how much weight should be given to those views? Competence is a threshold concept. We've either got sufficient competence to make a decision or not. But I think autonomy could be viewed much more on a continuum. And so somebody who is lacking capacity to make a particular decision would still be expressing a certain element of autonomy and trying to express their wishes. And these wishes could be expressed through, they can articulate their views, their non-competent views, but through behaviours. And at least in England, we would take this is a statement in Re C, the further capacity is reduced, the lighter autonomy weighs. And I think what Justice Thorpe is saying here is the further away from capacity you have, the less weight should be given to these non-competent expressions. I'm not sure if that still is the case after the Mental Capacity Act. And I don't want to spend much time on this, please don't get freaked out by this slide. But I think this is an interesting point, isn't it? Because if a patient has, when they've got capacity, said, yes, I would want that treatment, and now when they don't have capacity, they say, well, I do want the treatment, I don't want the treatment, then which weight do we give? Greater weight to the previous competent wishes, or now a patient is making a different sort of judgment when they lack competence? I don't think there's any clear answer here. And we can see that the courts have not been particularly clear. But it seems that both in the case of Re P and Re S, these are English cases, the court says particular view should be given to the wishes expressed by the person when he had capacity. So in other words, we might take particular weight of views expressed by the person at a previous time when they had capacity. Does that mean we ignore their current non-competent views? No, I don't think we do. But that's where the problem arises, I think. And Dresser argues that previous competent preferences should not bind a person when they now lose capacity. So how much weight do we give to the patient's wishes, values, and beliefs? It's clear, at least from English law, that those values and beliefs and wishes are not determinative. They must be considered, and that they obviously will influence the decision, but they're not determinative. And how would we know the patient's views? We'll ask those close to them, carers, family members. I think that's quite a difficult discussion to have. And also, what are we asking the family to do? Are we saying, well, what would the patient want? What would the patient think about this? What do they think is best for the patient? I think this is very difficult. It's very difficult for the relatives too. And it's quite clear that actually, when we look at surrogate decision making, the views of family, when they're asked to make surrogate decisions for their loved ones, are often wrong. So the family's accuracy in predicting patient preferences has consistently been shown to be poor to moderate. And this can often be the case that surrogates, so family members perhaps, might more often choose what they would want rather than what they think the patient wants. I'm just going to skip this because I want to spend some time looking at this case. Now, this was a case heard by the High Court the judgment was issued in September 2011. And let me give you a bit of background to this. So this woman, described as M in the court, was described as very independent, very active. She took her dog for a walk. She was literally about to go on a skiing holiday, and her partner couldn't wake her up. She was drowsy. So they called an ambulance, and she was taken to hospital. And she was very, very suddenly ill. She was diagnosed with viral encephalitis. She was in a coma and never recovered. And she had extensive and irreparable brain damage. She was described as being in a minimally conscious state. So this was the diagnosis. And I may be corrected by some experts here, but as it was described in the court case, she could feel pain. And she was described as experiencing pain about a third of the time. She was aware of light. She could grunt, so she had some awareness, but it was quite minimal. And there was no prospect of recovery. Now, she hadn't made an advanced decision, an advanced directive, and my argument would be, well, why should she? She was well, she had no underlying medical condition, so there wasn't really any reason why she should make an advanced decision. And the case came to court because she had been fed artificially since 2003, so a long time. And her family said, you should withdraw feeding, and the issue went to court as to whether feeding should be withdrawn. And I'm just going to give you the different perspectives of those caring for her. So the family, M's partner, the woman's partner, who she lived with for a long, long time, 17 years I think, and her sister. And they were contrasting her life now with her previous independent, active life. And they said, she just wouldn't want to live like this. She would be horrified living in this condition. The sister recounted how M had felt after visiting their grandmother in a nursing home, and said that M had told the sister, if I'm ever like that, I'd rather live less by 10 years than be looked after like that. And on publicity of the Tony Bland case, so this was a very important case in England around patients with PBS, she said, what a dreadful position to be in. So the family, I think, are trying to articulate what they thought she would have wanted. And their view was it wasn't in her best interests to have treatment, to continue treatment. The views of the clinicians was different, actually. So one expert, Dr. Badland, who was, I think, an expert neurologist, said he thought the quality of M's life was reasonable. And he thought artificial nutrition should be continued. But another expert said she was unable to see any aspect of M's life that gave her positive pleasure or satisfaction. So really, for Professor Turner-Stokes, there was nothing in the best bit of the benefits in the best interest analysis. And we can see, even with these two experts, there's a difference of value, isn't there? There's a difference of opinion. And then the views of the professional carers. And they were much more positive than M's family about her quality of life. They were describing her behaviours. So they were saying, well, you know, she can clearly track and move her eyes. She can make noises. When certain music was playing, she was crying. And she could obviously feel discomfort. She moved her arms when she was pushed over rough ground. So, my question to you is, well, what factors are you going to put in a balance sheet? What might be some benefits of, so the treatment here was considered to be artificial nutrition and hydration. So what might be some benefits of continuing with the treatment? Can somebody shout out some views? You're going to preserve her life, aren't you? You're going to sustain her life, yeah. So if you don't continue artificial nutrition and hydration, then she's going to die. Are there any other benefits to M of continuing with her life? Continuing with her artificial nutrition and hydration?
She's able to track, she's able to respond to the stimuli environment, so she's not completely unaware.
Okay, so she has some awareness, and that awareness might be a positive thing, mightn't it? It might be a benefit, but that awareness may also be a burden if she can feel pain, and if the pain can't be remediated through medication. But we've already identified two benefits, yeah? What about burdens? How would we think about the burdens of continuing with artificial nutrition and hydration? Are there any burdens? So she's in pain.
Prolongation of suffering.
Sorry?
It could be prolongation of suffering.
Prolongation of suffering. She's in pain. By keeping her alive, we're continuing her suffering, yeah? Say again? The burden of the carer, yeah? And how that might be relevant, yes. So shall I ask, what do you think? I won't ask what you think, but what do you think the court said? Do you think the court said that, and the burden, sorry, I should just point out, I think what the burden is, you know, if we're taking section 6 of your Mental Capacity Act, it says the past and present wishes and feelings of the patient, the values and beliefs that that person had. Now, we don't know her present views, but the family were trying to articulate her values by saying she wouldn't have wanted this. She was an independent person. What do you think the court decided? Do you think they decided, who thinks they decided to continue the treatment? Who thinks they decided to discontinue the treatment? And a lot of undecideds, okay. I'll show you what the court did consider here. So they did say that the patient's wishes and feelings were relevant. And we can see that the court says, look, I believe her partner and her sister. I believe what they're saying is true. But they're saying that the statements that they were kind of bringing in evidence were not specifically directed as to whether M would want artificial nutrition and hydration in a minimally conscious state. I think that's setting a very high level of values to be produced, actually. And also saying that, this was 8 years ago. So the court was saying, well, okay, I do take into account the wishes of M's feelings, her previous wishes and values, but I'm not going to give effect to them because the factor which is of substantial weight in the balance sheet appraisal is preservation of life. So on the benefit side, preservation of life was very, very weighty and outweighed the burdens of continuing suffering and not what the patient wanted. I'm not sure whether you think that's the correct decision. I suppose we may all take different views about that. I think it illustrates at least the weight given in English courts to preservation of life.
Caroline,
Yes.
can we ask you to speculate on what grounds do you think that this factor, which is a substantial weight, this preservation of life, which favors the court in deciding to continue with the treatment, will be defeated? What hypothetical scenario in which this?
Well, this is something I'm very interested in. I think it's a great question, because if we're saying that in determining best interests, you've got a balance sheet approach, and if the court is always saying, or as it seems to do, is giving great weight to preservation of life, then my question and my argument is, well, what can ever offset that? And so can any prior views or feelings of a person ever offset preservation of life? And I think that's quite difficult to do. You might disagree with that, but I think that's very difficult to do. And if I could explain why, and then I'll try and answer your question better. It seems to me that what we've got here is different narratives, haven't we? We've got different accounts of the patient's best interests. So we've got perhaps, because, that kept you awake. I'm so sorry. I'm probably going to... Okay, I'm so sorry. We've got different narratives, haven't we? And the question is, well, which narrative predominates? So we might have the narrative of the patient articulated by family and carers. We might have the narrative of the healthcare team. And also maybe the court, if the court is getting involved. And my question really is, well, what weight should be given to these different narratives? What weight should be given to the patient narrative? Now, I'm not going to read all of this, but I just think this is a very interesting concept. I'm going to press the right button. So this is a statement to say, well, really, we should try and continue the patient's narrative. In other words, this is a question, I suppose, rather than anything else, but do we have an obligation to continue the patient's story of their life? In other words, we are all, I suppose, exponents of our own stories of our lives and our own values and etc. Should we be making decisions for the patient which continues the story of their life, continues their values? And I think there's quite a lot of, discussion, but actually we should. Now, the question is here, there were different articulations of the patient's story. So the partner said, I think she would be horrified she was carrying on like this. And the sister said, I know she wouldn't want to have continued treatment. In her heart of hearts, that's not what she would have wanted. And my question, I think, really is, well, how can these values be evidenced? So you might have clear clinical evidence. If we do this, then, or if you're going to withdraw artificial nutrition and hydration, the patient will die. How can we evidence what the patient would have wanted? And now I'm talking probably where there's no advanced care planning or advanced medical directing. And I think this is a rather nice concept developed by Anita Ho, who says, well, clinicians tend to be viewed as experts in this, in best interests, because, they are presenting medical data. She says, by comparison, lay people, family or friends, are appealing to different sort of arguments, to more sort of visceral arguments. And so in a sense, we're comparing different things. And so to come back to your question, I think my view would be that where we're talking, and I'm only really talking here about life-sustaining treatment. So I suppose artificial nutrition and hydration, probably artificial ventilation. I think because the withdrawal of these treatments necessitates the ending of the patient's life, at least the English court is putting enormous weight on preservation of life. And my argument, I think, would be that the patient's values, wishes, feelings and beliefs are not really given weight, partly because how can they be? How can they be evidenced? Now, you may disagree with that, I'm not sure. So Ho considers that we should have some sense of humility towards different accounts of best interests. So she's arguing that clinical assessment is really only part of the story. And the clinical aspect of best interests is limited, really, because as healthcare professionals, you're not going to know the patient's story. You're not necessarily going to know, especially in an emergency setting, you're not necessarily going to know their values and beliefs and what's important to them. So I think it's these contextual factors of best interests that are problematic.
Caroline, sorry to...
Please.
Did the courts review any aspects of public policy in their consideration, like the fear of going down the slavery slope if you start defeating sanctity of life in such very conscious issues? Was that something they touched on and considered?
The court didn't think about, as far as it was a very long document, 79 pages of judgment. And the court, I don't think, was articulating slippery slope, no. What the court was keen to do was to say, well, best interest is wider than just clinical best interest. They recognised that. They recognised the truthfulness of M's family in articulating what her values and beliefs are likely to be. But I think the reason that they came to the decision they did was that to offset preservation of life, you need pretty weighty evidence, wouldn't you? And this sort of articulation of the patient's prior values 8 years ago, because she'd been in a minimally conscious state for 8 years, without reference to, anything specific. So she wasn't saying, well, if I'm in minimally conscious state, I wouldn't want to continue to live. Then the court said, well, we just can't give significant weight to those views. I think it's very difficult, though, for patients to really make their values, wishes and beliefs clear. And maybe that's why we should all do some form of advanced care plan. Yes, sorry, Jim. Yes?
I've got a question. I'm just wondering for this particular case, I don't know the details, I just read very superficially on the case. But would such a case be surfaced to the hospital by ethics committee to decide at that level, rather than go to the court? So I'm just wondering if it goes to the hospital by ethics committee, and what would have been the decision? And
well,
surface right to the court.
Well, I think that's a very good point, because this has set a very important precedent, but it's also very costly and very emotionally draining, I would imagine, for the family. There was a very interesting case in 2001 in England about a woman who was tetraplegic and wanted her ventilation removed. And the judge there said this issue should have gone to the Clinical Ethics Committee, because then it could have been resolved at a local level without going to court. So we have a very clear statement in that case that actually that would have been a better way of resolving it. Do you think this sort of case could be resolved in a Clinical Ethics Committee discussion?
I just want to say something about the Clinical Ethics Committees in Singapore. Their remit is advising. So Initial refers to the case, or refers to the case, and they give the advice, but it's not an executive body which makes any kind of decision. So in the end, the decision remains with the clinical team.
Yes, and thank you, and that is also true in England as well. So the Clinical Ethics Committee is advisory, they can't mandate the doctor to do anything. But I think what it would have done would have been given an opportunity for everybody's voices to be heard, wouldn't it? That's not to say it would necessarily have gone, that might not have stopped it going to court, but I think it would have enabled those dialogues to be heard and considered in a better way.
Just one follow-up question. Could there be a possibility of further appeal to a higher court and get different decision?
This case was not going to be appealed. And I think that the worry is that this sets such a clear precedent, actually, about people in minimally conscious state and the weight given to preservation of life. So I suppose, somebody else could bring an action. And in fact, the court said there that these sorts of cases should come to court and should be legally aided. But the question is how much this sets a precedent for further discussion.
Sorry, I did want to raise a question which strikes me as quite central in cases of PDS and minimally conscious patients. Very frequently, the anguish of the family and is an issue in continuing the care. And that factor doesn't seem to, in this case, the family said, withdraw care, but it's frequently the case that you may think of continuing treatment as futile, if you think it's used to it, or if you think that it's physiologically futile. But it's very hard to say that care is futile. Continuing to care for somebody is futile. No one wants to admit that. So I think it is for this reason that it's very hard for people or doctors or families to say, stop, because it's the limitation of our caring. We find it a burden, And then the other thing is, in one of the cases that you've drafted here, it's the woman who's got a poor home situation, and the care is not adequate, community care is not adequate. And we don't want to admit that we can't provide a decent level of care for people, and so we just say, we leave her in the hospital and keep caring for her, or just we can't let her go, to something.
But I think that raises very different cultural issues about how we feel about caring. And certainly in England and Wales, we don't have that same degree of, I think, the obligation to care for people, I don't think is so embedded as in your culture here. And I think that raises a very interesting question about what about when the family have had enough? When the caring for a very ill person is a burden to the family. In other words, how much should we take into account the family's view, the burden on the family in determining the patient's best interest? And I just wanted to I think this is a lovely statement from a very short novel. But here, the author is saying, the patient wants the nightmare to end, and so do his family. They've had enough. They're as ill as he is. And for them, the anguish of caring or knowing that you have a relative who can never get better and is being kept alive can, I think, be a torment. And so I think we should recognise that it's very difficult to separate out best interests of the individual and best interests of the family. The interests are intertwined. This is just saying that actually Section 6, I think, does, the listening English law, would allow us to think under all, you have to think about all relative circumstances. And what the courts in England are saying is, well, that might include the impact on the family. I want to, yes?
Sorry, Dr. Johnston, but with regards to the case that we were talking about, I was just thinking that if we are talking specifically about best interest of the patient per se, so not even considering the carers whatsoever, and while I agree that the sanctity of life is a very noble aspiration that we would want to uphold, the sanctity of life per se, I would have thought that that's not necessarily in the best interest of the patient as such. especially in light of the case where we say that the patient is still capable of feeling pain, but perhaps is unable to articulate the pain that they are experiencing. So by upholding the sanctity of life, we are also prolonging this patient's suffering, and just that alone to me suggests that this is not in the best interest of the patient. I mean, in disregarding the carers away from this issue per se. So I don't see how, I mean, although I respect the court's decision, I don't see how the sole argument of preservation of sanctity of life is in the best interest of the patient. If you get what I mean.
Well, and I think that really comes to the nub of the issue. In determining best interests, how much weight are we giving to a value of being alive, of preserving life, and how much are we giving to quality of life? And if we're thinking about quality of life, how poor does that quality of life have to be, and from whose perspective? And the problem is, of course, when we have an incompetent person like Em who can't articulate that, we don't know. We're imposing values, and as I hope I've shown, different people will have different values. And you're right. I think that would be up to judges to decide where the weight is falling in preservation of life and equality of life. And in this particular case, and I guess they're all fact specific, in this particular case, the court was saying, you know, although she feels pain some of the time, we think that preserving her life is going to be better than allowing her to die, because we don't have any clear articulation of abuse. But I think this is exactly the nub of the problem. Yeah. Can I just show you this case then, so that I'm going to whet the appetites of those people who are going to stay for the workshop, and for those of you who are not staying, illustrate what a good discussion you're going to be missing. This is the case we're going to be looking at. I'm worried I'm going to fall off the stage after the break, and apparently it's a local case. So let's have a think about this. A youngish man, healthy, he's Buddhist, and he works as a construction worker and has a fall, and he's left very, very seriously injured. So multiple fractures and a severe head injury. He's weaned off cardiorespiratory support and is able to breathe through a tracheostomy, but is fed through a peg. And 2 years on, there's no improvement. Neurologists say he's in permanent vegetative state. Now that, it seems to me, is quantifiably different from minimally conscious state, because he will be insensate and can't feel pain. Now I'm surprised about this, but apparently he's cared for at home by his widowed mother. And this is obviously a burden to her. And resources for his care are minimal. The family find the idea of withdrawing support unbearable. So I think they can recognise that, you know, gosh, this is hopeless, but they just can't bear to articulate the idea of a withdrawal. And the team considers that overall it would not be in the best interest. Now, I've highlighted this in red because this is the way the information is presented to me. And I think it's quite interesting. It doesn't say not be in the best interest of the patient, but it says in the best interest. So I think that's, you know, whose interest are we thinking about here? So it would not be in the best interest to continue to keep him alive, especially in view of the burden faced by the family. So, we've got lots of issues here, haven't we? How are we going to determine best interests of, now I would argue, best interests of the patient, because that's what the Act is asking us to do, but obviously we've got to be thinking about, you know, the wider view as well. And these are some of the things I think are relevant, and I'd be interested to see what else you might want to add or disagree. So issues that we might want to consider. So we might be constructing a balance sheet in determining whether it's in Mr. Chan's best interest to withdraw the peg feeding and the tracheostomy, and that would result in his death. So we could think about the benefits and burdens. Well, one benefit might be preservation of life, but we've already had a good question about that. How do we evidence the benefits and burdens? So you know, what sort of evidence can we bring to illustrate the benefit of keeping it alive and the burdens? As I understand it, you know, as a Buddhist, Mr. Chan would give great weight to preservation of life, sanctity of life. If somebody believes that life should always be preserved, then what sort of weight should we give to Mr. Chan's religious views here, or the views he previously espoused? What's the relevance of Mr. Chan's quality of life? I mean, we may all have different views about whether that would be a quality of life we would want to accept, we would find acceptable. But we're looking at this objectively as far as we can. Does Mr. Chan have such a poor quality of life that it is not worth preserving? But from whose perspective are we thinking about that? Mr. Chan's? Our perspective? A so-called objective perspective? If you remember, one of the things I thought about right in the beginning, that sort of schematic diagram, well, what's the purpose of treatment? And is treatment futile? So the peg feeding, the purpose of the peg feeding is to keep them alive. Can it be futile then? So we might think, well, what's the purpose of treatment here? I think it's also interesting to compare withdrawal of feeding from withdrawal of other treatment. Is there something different? I don't know the answer to this, but there seems to be something instinctively perhaps different about withdrawing of food, albeit through a tube, than other treatments. You may disagree. Now, one of the burdens that we might be thinking about, and we thought about in the case of Anne, was the pain that the person is suffering. So if somebody is suffering pain as a result of the treatment they're receiving, or just by being alive in their condition, that might be a burden. But if Mr. Chan is in PVS, he's not feeling pain, is he? So is the pain he's feeling, any pain, a burden to him? And also, what weight should be given to the family's views? What are they being asked? They're not being asked really, do you agree with withdrawal? I mean, clearly one wants to know that they don't disagree and that they're on board with the decision. Are they being asked, what would Mr. Chan want? Are they being asked, what are Mr. Chan's values and beliefs? And how much weight would we give to their views? And I think particularly interesting here is it appropriate for the team to consider the interest of Mr. Chan's family, his widowed mother, the overburdened sister, in deciding what's best for him? So, well, I've got no time to answer those questions now. I'll leave you to think about that. Does anybody, just before we finish, does anybody have any particular comments about Mr. Chan and what might be in his best interests? Yeah. Yes.
I think the burden, I think in the Singapore context, the burden is borne mainly by the family, because the respite care is very expensive here. So there's a lot of issues that are not lightening the family burden. So I think there is a lot of social input as well for the patient. Yeah, and then the other aspect of it is that what's the evidence for the persistently vegetative state? How long is it? Then you consider that it is like no recovery. Yeah, so there are incidences, so you need to know evidence too.
The patient is at home being looked after by his family, and he's not in the hospital. So I'm just wondering why the hospital team is so concerned about the Mr. Chan's family, because they have not raised this as an issue, and I don't know in terms of cost what it would cost the family, but I thought any decision or any decision to continue with the patient's treatment will have to come from the family rather than from the team in the hospital. I could understand the problem if the patient is stuck in the hospital and the family refuses to take the patient home. And I suppose that it becomes a rather tricky issue because it sort of compromises treatment and other difficulties that may arise.
I agree with that, but I think also, and this is the tricky bit, that sometimes it will be against the patient's best interest to be kept alive. So if a patient is suffering and if treatment is futile, then I think we would say it is not in the person's best interest to continue to receive that treatment. And then the question is, well, we're acting against the patient's best interest to keep them alive just because the family require it. And I think that's the tricky bit, isn't it? But I'm not sure we could say that it will be in the... It's not up to the family to decide. The decision is this treatment, ongoing treatment, in the person's best interest? And it's that decision that has to be made. The issue then is how to articulate with the family. And I think this is where we have a difference between perhaps, your perspective of care and the English issue of care. I've overrun, so I'm not sure I should take any other questions, except to say that I don't think there are any easy answers with this. I think best interest is really complicated, it's multifaceted, and all I would hope to do is to illustrate the difficulty of it and also the importance of the different elements and the process for decision making. Thank you.